So many of my clients have asked for an update on the legislative changes that have taken place in the state of Texas. The Texas legislature met in Austin and modified the way that Texas does evictions. These next few videos are going to be all about diving deeper into the code to give a broader explanation of what is now expected of landlords, but also what landlords can expect out of the eviction process. So one of the things that plagued the state of Texas and many other states during COVID were all of the different ways that different courts and different judges and even different regions of the state were handling eviction matters. Because many property owners and investors own property in the same state, but get very different results. So the state legislature met in 2025 to make sure that the laws as of January 1st of 2026 are uniform. And I want to talk about that uniformity and what you can expect in terms of how things should run in January of 2026. The legislature said that's enough with renegade courts or renegade counties or cities making up their own eviction rules. Section 24.0043 prohibits counties or cities from making their own rules which affect eviction procedures. Specifically, the legislature is the only body that may modify or suspend procedures prescribed by this chapter. What this means is that in response to all the things that were happening during COVID, where city council was stepping in certain cities and changing eviction procedure, maybe requiring more time in a notice to vacate, or requiring landlords to jump through certain hoops before they were able to evict, whereas in other counties, whole counties were changing the way that evictions could proceed in response to the COVID emergency. Texas instituted some emergency procedures and emergency requirements for the way foreclosures were carried out and the way that eviction court could now be held on Zoom. In some ways, emergencies are going to do this in a short term. However, with regard to procedures that courts have to follow, the Texas legislature said we're not going to allow individual cities or counties or courts to have their own set of rules. This code provision goes on to say this section does not affect the authority of the Supreme Court to modify or suspend certain provisions for the conduct of any court proceeding affected by a disaster under section 22.0035B of the Government Code, but such a modification or suspension may be applied to an eviction only if the modification or suspension is applicable to all courts similarly affected by the disaster without regard to the subject matter of an action, and any request for the modification for suspension is made in writing and available to the public. Unfortunately, what was happening all over the state of Texas is there was no such uniformity. Like I said, Austin was doing things differently than they were in Corpus Christi. The Valley was doing things differently than they were up here in Houston. And Dallas and El Paso, cities all over the place, city councils were meeting, county judges were meeting, and just changing the law as they saw fit, giving requirements to landlords that were not present in the Texas Property Code. They were only present at that city council meeting. And the moment these laws went into effect in those jurisdictions, landlords were left having to scramble to figure it all out. That's out the window now. Only the Supreme Court can make changes in a disaster situation, and all of those changes have to be made available to the public. Now, one thing that's still common in all courts is the institution of local rules. So different courts might have different expectations and different requirements for things like forms or the way that people dress or the conduct that's allowed in the courtroom. But the legislature has limited what the court can do in terms of its own local rules when handling eviction matters. The legislature meant for eviction to be a quick process without all the same bells and whistles that go on in regular civil litigation. Section 24.00506, subsection B says, a court may not adopt local rules, forms, or standing orders for eviction suits that, 1, require content in or with the petition other than the content required by the Texas Rules of Civil Procedure. In other words, a local court can't just require you to include a certain thing in your eviction petition or exclude a certain thing from your eviction petition. If it's in the property code, it must be in that court's rules. Anything else ain't allowed. Subsection 2 says they can't require any mediation, pretrial conference, or other process before trial. This is a common thing where courts were requiring landlords to try to work things out with their tenants, which is not necessarily a bad thing. However, sometimes the court would order the parties to seek mediation help outside of the courtroom, and that meant delay in the process. Many times landlords had their cases reset until they could prove that they had attended mediation. And in certain situations, this is difficult because the tenant who wants to do everything possible to extend their stay simply wouldn't cooperate, wouldn't give dates of availability, or was constantly unavailable to mediate, thus extending the process and not allowing the landlord to show up to secure their judgment for eviction. When a tenant had gone weeks or even months with non-payment, these tactics would add delay unnecessarily to the process. But the legislature has now stepped in and no longer requires landlords to jump through these kinds of hoops. In fact, the legislature says the local rules cannot allow it. Furthermore, Texas Property Code 24.00506B, subsection 3, prohibits a court from authorizing the dismissal of an eviction suit on the basis that the petition is improper if the petition meets the requirements of the Texas Rules of Civil Procedure, or the petition can be amended to meet the requirements of the Texas Rules of Civil Procedure. In numerous instances, judges were dismissing cases because an improper party was present in the case, or perhaps a name was misspelled, or the address was improperly put in the eviction petition. And on that basis, the court was simply dismissing these cases. But now the legislature says, look, if the petition adheres to the rule, and if that modification can simply be amended, made to the petition, you can't just dismiss the case outright. The landlord should be allowed the opportunity to amend their petition. Even if the case has to be reset, it shouldn't amount to a straight dismissal, having to have the landlord refile, reserve, and attend trial again sometime in the future, extending the process unnecessarily. If a landlord had an error that can simply be fixed with a simple amendment, then the court should allow that amendment to proceed without a dismissal of the case. Essentially, landlords should be allowed to proceed with their evictions in spite of the fact that they may have had some small error that can easily be fixed. This should improve the eviction process by not requiring landlords to unnecessarily file again. This next modification of the Texas Property Code has everything to do with the Justice Court sitting on a case and not allowing the process to proceed on to the county court once an appeal has been followed. In fact, many times the procedure in different courts was all over the place, and it was difficult for landlords to navigate the appeal process. Even for us attorneys, it was difficult to navigate these processes because certain courts operated in one way, but even within the same county, other courts would operate in a completely different way. Now the legislature has stepped in to make things uniform. Section 24.005107 subsection B says the following: the Justice Court shall forward the transcript and original papers in an appeal of an eviction case to the county court by electronic means or otherwise, not earlier than 4 p.m. on the 6th day or later than 4 p.m. on the 10th day after the date the tenant files the appeal, except that if the court confirms that the tenant has timely paid the initial rent payment into the Justice Court registry in accordance with section 24.0053, the court may forward the transcript and original papers immediately. Now, what does this mean? You may not have caught it, but there are two important dates in there. The first says that the court can't simply ship the case off super fast. Unfortunately, I had an instance where a court shipped the case off before the day began. And so even though it was the first available day for a landlord to seek a writ of possession when a tenant failed to pay the rent into the registry, because the court had already shipped the case off, the landlord had no opportunity to secure that writ. The rule now says you can't do it before 4 p.m. the day after the rent is due into the registry. The reason this is important is because the tenant has a deadline to pay into the court registry based on this type of appeal. And if they don't make their payment in accordance with the rules, which require payment by the 5th day by 4 p.m., then the landlord is offered an opportunity on the 6th day to get a writ of possession. So this gives a landlord a full day up to 4 p.m. To secure that writ of possession, as opposed to having no opportunity to ever secure a writ of possession in the event that the tenant has failed to pay into the registry. The other important date is day 10 after the filing of this appeal, because sometimes courts received funds or received no funds, but simply sat on the case for weeks and never shipped it to the county court, thereby prolonging the process unnecessarily. In this case, the court cannot hold on to an appealed case for longer than 10 days. This rule now speeds up the process and disallows the Justice Court from simply sitting on a case and creating unnecessary delay between the Justice Court and the county court once an appeal has been filed. And in the event that rent is owed, once the court has received that rent, there is no right for a writ of possession for the landlord, so the court may, on that day, immediately following the payment, ship the case to the county court, but they can hold on to the case up to 4 p.m. on the 10th day, but no later. Landlords, it's important for you to know these particular facts, or it's important for you to have access to someone who does know these facts well, so that you can utilize them in your planning and in your strategy when you are dealing with a tenant that you're having to evict. Understand that the eviction process takes time, but it also takes some patience and a clear understanding of the rules, so you know as soon as a right kicks in, you can exercise that right. By being sure you know how these procedures work, you're going to take advantage of the rules without being taken advantage of by your tenants who understand that they have a right to an appeal, but when you know how the rules work, you can make sure that the appeal rights work in your favor. Landlords, if you have learned something today, if you've enjoyed the video that you've watched, please give us a like. We really appreciate when you do that. If you've got a question or a comment, leave that for me below. I will personally review it and answer that question to the best of my ability. And if you're not yet a subscriber, please consider subscribing to our YouTube channel. We hope that you enjoy the rest of the videos, particularly about the legislative updates in the state of Texas beginning January 1st, 2026. YouTube seems to think that this video right here is the next best thing for you to watch. Check it out and all the rest of the videos in our catalog. And until next time, landlords, happy leasing.